with the legal mandate to promote human rights both in Denmark and internationally. And we're one of around 100 national human rights institutions with that mandate worldwide. So there's probably one in the country where you participants are sitting now. And unusually, amongst national human rights institutions, the Danish Institute for Human Rights for the last 15 years or so has focused particularly on the issue of business and human rights. And as part of that work, we have undertaken over the years direct corporate engagements with various large multinational enterprises as supporting them to integrate human rights into their policy commitments, procedures, and country-level activities. And it's really partly from the basis of that experience that we've had with those companies that I'll be speaking to you today about procurement and human rights. As it's coming up for Christmas, if we think just for a moment about one of the products which probably a lot of young people will be hoping to get in their Christmas stockings this year, this kind of electronic product, of course, has for many people very positive associations. Electronic goods like this are things which make our lives easier, which are representative of the technological future, and generally products which are held in high esteem by the people that have them. Apple as a company, of course, is also a very profitable venture, making world record-breaking profits of $18 billion in the last quarter of last year. However, Apple products are manufactured, as are many of the contemporary consumer products that we all buy and rely on, through globalized chains of manufacture and production. And we see here on the left a picture of one of Apple's plants where the company Foxconn, one of its main suppliers, assembles Apple iPhones in Shenzhen in China. And during the course of production in Shenzhen, each of the Apple iPhones will pass through 350 pairs of hands. So actually it's a very handmade product. There are somewhere between 250 and 350,000 workers at one of the main manufacturing assembly plants of Apple in Shenzhen. To give you an idea of the kind of work involved, one person working on that assembly line would have the responsibility for meeting a target of deburring, which means smoothing the surface of the back of the iPhone 3,000 times during a shift of 10 or 12 hours. Each of those workers typically would be working in the region of 60 to 80 hours per week. So if you do the math, you can see that's a lot of repetitive actions and really quite a demanding workload for any individual who's part of that assembly line. Equally, there are around every week 3,000 migrant workers at the gates of the Foxconn plant in Shenzhen seeking employment, which of course creates dynamics which are more favorable to the employer than to the employees in terms of any grievances that they might have about the conditions they work under. And over the last 4 or 5 years, it has been revealed through investigative journalism and by organizations supporting workers that these conditions at Foxconn have been not found to be tolerable by the workers, and there have been very negative human consequences on the workforce. In particular, health and safety related injuries and stress, leading in some cases to, and very prominently, to a set of worker suicides at the Foxconn plant. The consequence of that has been that Apple has attracted very negative publicity in relation to the conditions at its suppliers. As you can see here, some of the graphics which have been produced by media and civil society outlets in relation to that. So we can see that these are very real questions that we're going to be discussing today about procurement and human rights, and hopefully over the course of this session, I'll be better able to explain what is the specific role and value of introducing the language and concepts of human rights in this area. What value can you as procurers derive from working with human rights standards and concepts in this area? And maybe I'll be able to, if we have time, explain to you a little bit some of the approaches which have been used by purchasers in order to overcome the sorts of challenges that we've just seen here in relation to Foxconn. So to get back to basics, human rights, what are they? We often talk about corporate social responsibility and sustainability, so it's important to understand, before we embark on a bigger discussion of the role of human rights in the context of business, what is the difference between a human rights approach and a CSR or sustainability approach. The differences that there are really come from the fact that human rights, as we see here, are universal legal guarantees protecting individuals and groups, both in relation to fundamental freedoms and human dignity. So the key points to come from this definition that is on the slide in front of you is that human rights have a legal basis. That means that there is a certain and definite content to human rights. Although we can find in conversations that we might have amongst ourselves or interactions that we might have with civil society groups, that human rights language is used in a variety of ways and to support different kinds of campaigning positions. It's very important to understand at the beginning that there is a specific content to human rights, and that really helps us to disentangle some of the claims that may be made about human rights to us. The other important point is that human rights are universal. That means that they should be respected as a minimum standard of treatment for everybody, regardless of personal characteristics, and in general, they should be respected everywhere in the world. There are, of course, some variations in the finer details between countries, but most human rights should be honored and respected everywhere around the globe. And the standards that are in place in relation to human rights are principally those which have been transacted in the United Nations system. And the most important of those is the Universal Declaration of Human Rights of 1948. But in addition, there are a number of more specific instruments which focus on different areas of human rights, or indeed different groups of human rights holders. So in addition to the international covenants on civil and political and economic and social rights there are equally conventions which specify in greater detail the rights of groups such as children, women, racial minorities, indigenous peoples, and migrant workers. Another very important aspect of human rights standards are those of the International Labour Organization. And although the ILO was established in 1919, in 1998, the ILO brought together its most important standards and put them in a single document, the Declaration of Fundamental Principles and Rights at Work. And the four areas which that standard addresses are freedom of association, freedom against child labour, freedom against forced labour, and discrimination in the workplace. In addition, in most regions of the world, there will be a regional human rights convention. Here we can see the African Charter. There's also conventions in place in Europe and in the Americas, and also in the Arab region, which give, again, further elaboration to human rights standards in those contexts. Finally, many national constitutions also contain specific protections on human rights. So this is the catalogue of standards that are relevant for a government or indeed for a business, as we'll be coming on to see when we talk about human rights. Originally, in 1945, when Eleanor Roosevelt and all the other illustrious figures were drawing up the Universal Declaration of Human Rights, they envisaged that they would develop a minimum standard at the international level of these basic freedoms and entitlements to dignified treatment for everybody. Those would be protected by individual states through national law. That public actors, be that the police, the judiciary, health care systems, schools, and so forth, would also act in alignment with international human rights standards. And at the end of the day, you and I would have our human rights respected because of the cascade of protection from the international to the local. However, in the later part of the 20th century, it became increasingly acknowledged and drawn attention to that multinational enterprises in particular, as a non-state actor or as a private actor, were also possible perpetrators of human rights abuses. And it became clear that the intended cascade of human rights from the international down to you and I locally was not working as was intended. National laws might not be in line with international human rights standards, or indeed public actors and non-state actors such as companies might not act in accordance with those national laws, even if they were there. This brought really a strong focus on the question of what human rights standards should apply to businesses as non-state actors, and what should be the appropriate division of labor, if you like, between governments and businesses in relation to human rights. And some of the dilemmas that were raised in relation to that were about whether you could expect businesses to meet all the same obligations as governments in relation to human rights, and it seemed that wasn't appropriate or desirable. The government, for instance, has got a responsibility to maintain a functioning judicial system, and that's certainly not true of a company. So there were clear dilemmas and controversies in trying to define a conceptual framework that would both recognize the possible influence and impacts of public and private actors on human rights, but which would not have unintended or perverse consequences. And that controversy raged for a number of years in the late 1990s, up until the point when this gentleman, John Ruggie, who was appointed by Kofi Annan to be the special representative on business and human rights, came up with the UN Guiding Principles on Business and Human Rights and the UN Framework on Business and Human Rights. And the UN Guiding Principles and UN Framework were unanimously endorsed by the UN Human Rights Council in 2011. Subsequently, they have also been strongly supported or endorsed by the European Union, the OECD, which aligned its its guidelines for multinational enterprises with the UN Guiding Principles, by international financial institutions, industry bodies, large groups of investors, the ISO, and many national governments in addition. And in relation to national governments, currently there is underway a movement by national governments to develop national action plans based on the UN Guiding Principles. And all those countries that you can see now have either published a national policy intended to promote the UN Guiding Principles on Business Human Rights, or are in the process of doing so. In fact, Ireland was the most recent of those, just launching its draft National Action Plan on the Guiding Principles yesterday on Human Rights Day. So what's actually the content of the UN Guiding Principles and UN Framework? There are three main elements. The first element of the UN framework is the state duty to protect human rights. This simply states that while businesses have got a responsibility in relation to human rights, the state retains the primary duty to protect you and I against any abuses of our human rights for which businesses might be responsible. And that's a duty which the state should fulfill by creating an appropriate regulatory framework and ensuring that in its policies and legislation it adopts positions which are coherent with this overall position in areas such as public procurement, export credits, trade and investment policy, and so forth. The second major element of the guiding principles is the corporate responsibility to respect human rights. And according to the corporate responsibility to respect human rights, companies have not a duty identical to that of the state. They have a shared but differentiated responsibility, which is just to not themselves do harm to human rights or be associated with human rights abuses through their business relationships. The third pillar of the guiding principles is access to remedy, and that entails that anyone whose human rights are impacted adversely by a business activity should in one way or another be able to challenge that and have a remedy in order to put right any damage to their human rights that have resulted. And that can be through the court system, that can be through non-judicial mechanisms such as conciliation, mediation, or national contact points under the OECD guidelines for multinational enterprises. Or it could be indeed through a complaint mechanism at the level of an individual company or through multi-stakeholder initiative. And the scope of the guiding principles extends to all internationally recognized human rights. So rather than singling out specific human rights which are relevant for companies and others which are relevant just for the state, the guiding principles approach is to say that, subject to the qualifications that I've just mentioned, potentially businesses can be responsible for any for impacts on any human right. And just to give a little bit more clarification on the different responsibilities of states and those of companies, according to general human rights principles, states have got a duty to respect, protect, and fulfill human rights. Respecting human rights means doing no harm yourself to human rights, not actively harming human rights through your own conduct. Protecting human rights means taking steps to prevent third parties from abusing human rights, most obviously in the case of the state, for instance, through policing and having an effective policing system. Finally, fulfilling human rights is a question of putting in place the right infrastructure so that people's social and economic rights can be enjoyed in practice. And again, we think they're of having a road and transport, telecommunication system, healthcare, and education, and so forth. So according to the guiding principles and UN framework, it's only that first piece of respecting human rights, i.e. doing no harm, that is shared by businesses. Going into more detail about the corporate responsibility to respect human rights, we've heard that businesses have a responsibility to do no harm to human rights. And that means that through their own activities, they should avoid causing or contributing to human rights abuses. But in addition, they should also prevent or mitigate human rights impacts that may be directly linked to them through their business relationships. And that, of course, is relevant when we think about the procurement context. How are companies supposed to do this? According to the guiding principles, companies have to know and show their respect for human rights by exercising something called human rights due diligence. You may ask, what is human rights due diligence? The guiding principles explain this in some detail, and it's a process which incorporates a number of different elements. The first element is that the company should have a policy commitment explicitly to respect human rights. It should then initially undertake some sort of assessment to identify in what areas may its activities potentially impact on human rights. After doing that sort of assessment, obviously the company needs to respond to what it has found and adapt its policies and procedures in line with its potential impacts and what risks are identified in the first step. It's then expected to track and monitor its performance in relation to human rights, which of course entails the identification of indicators and measuring systems or approaches, for instance through social or human rights audit, questionnaires to employees, etc. Finally, the company is also expected to communicate publicly on its performance in relation to human rights, and to report on that, for instance, through its social or non-financial annual reports. Alongside, as part of the whole process, the company should engage actively with stakeholders, including rights holders who may be impacted by its business areas and activities, and it should also cooperate with anyone who is seeking to access remedy for business-related human rights abuses or with remedy mechanisms. The guiding principles also explain in greater detail a number of different ways in which companies can be connected to human rights abuses. The first one, most obviously, is where a company will itself cause some sort of state of affairs which can negatively impact on human rights. Here we have the example of a company polluting drinking water, and there is a human right to water, which is clean and healthy and safe to drink. A company that's depriving rights holders of that would be potentially responsible for breaching human rights. But in addition, companies can contribute towards human rights abuses. And here in the procurement context, we can think as an example of a situation where a company changes an order at the last minute, something which happens very often, but without adjusting price or delivery dates or other specifications, which entail that in turn the supplier has to demand excessive overtime of its workers. Another example would be where a supplier of security services, for example, has been engaged, where the supplier is responsible for human rights abuses of one kind or another. There have been plenty of examples of that in real life. A final third category of human rights impact would be where the company does not itself contribute, but nonetheless is somehow directly linked to operations, products, or services with a negative human rights footprint. And one example there would be where a company relies on public security forces for the protection of its property or personnel in a conflict zone, for instance. And in that scenario, if the public security forces are responsible for human rights abuses, we can say that the company is connected, even if it doesn't contribute to that situation. And of course, the last two of these are more relevant when we think about procurement and the connection of companies through their procurement to human rights abuses. In more detail, what should a company do in order to address these kinds of potential impacts which derive from its business relationships? According to the guiding principles, a company is expected in that situation to try to exercise leverage towards whichever entity it is that's causing adverse impacts on human rights. What is meant by leverage, and how is that defined in the guiding principles? Leverage is defined as a business's ability to effect change in the wrongful practices of an entity that's causing harm to human rights. Examples of mechanisms by which leverage can be exercised would include contract clauses that could be introduced, the requirement on tenderers to offer declarations of their compliance with certain social minimum criteria or certain minimum labor standards. Leverage could also entail engaging or requiring suppliers to engage in capacity building. Very often suppliers, especially in developing contexts, may be unfamiliar with the idea of minimum labor standards or the specific content of those sorts of standards. And it can be very beneficial for a purchaser to initiate dialogue with suppliers around those sorts of issues and to provide or support the provision of training and capacity building in that area. Working with other companies who operate in the same sector and the same geography as you in terms of their supply base can also be an opportunity, as well as simply talking to suppliers and initiating market dialogue around the sorts of risks that you identify that connect with human rights issues. Questions to consider when contemplating what leverage you might have also relate to how crucial the business relationship may be for you or indeed for the supplier you're working with. That, of course, will mean you have greater leverage than if you are a small drop in the ocean for them. Another relevant question is how severe the abuse is that you are afraid may exist in the supply chain. The more severe the abuse, of course, the more stringent you would expect the measures that you take to be. And then another question, a very important one to consider is when developing your response to any abuses you find in the supply chain is what will be the impact of any of the responses to that abuse which I might undertake. And the classic example here is that when child labor is found in some supply chains, it's not ideal by any means from a human rights standpoint to terminate those contracts immediately, because the likelihood is that where families depend on the income from those child workers will simply have an adverse impact on their immediate welfare and probably mean that the child is forced into another job, maybe even a more dangerous or hazardous job. So it's much better to engage with local non-governmental organizations, maybe educational authorities, to see what sort of more sustainable solutions can be identified that meet the needs of you to eliminate child labor in the supply chain, but which also support a sustainable transition away from child labor locally. If we think about these kinds of responses to supply chain risk and responsible purchasing practices, we can perhaps identify two phases. If we again turn back to the 1990s, the initial response of companies to some of these issues were typically to develop a code of conduct for itself, which might be passed on to suppliers through contract clauses. There was also a tendency to rely on social audit firms to inspect production facilities according to an agreed set of criteria and parameters. And there was also the birth at that time of social certification initiatives such as the SAI, SA8000 standard, and a number of other sector-specific standards in the apparel industry, for example. Over the subsequent years, it has been found that these sorts of approaches have not been fully successful. They no doubt have brought improvements in some areas. However, implementation gaps remain. And in response to that reality of persisting implementation gaps, compliance gaps in supply chain management. Some of the emerging trends and approaches that we see today are more collaborative approaches, which involve a broader range of stakeholders in tackling specific kinds of human rights abuse for specific products or sectors. We see a greater tendency towards initiatives that try to increase the transparency of supply chains and which try to encourage improvement in practices across supply chains through the requiring disclosure of information about them. We see an increased focus on grievance mechanisms, in other words, requirements to establish mechanisms through which workers or others affected by supply chains can raise complaints about those where they affect human rights negatively. And there's also the beginning of a discussion about responsible lobbying. So in the interests of coherence, it is understood that companies shouldn't, on the one hand, promote responsible supply chain policies and measures, and on the other hand, actually undermine the possibility of achieving responsibility at the national level by calling for deregulation or any sort of lowering of health and safety or labor standards. We don't have time to touch on all of these. I'll say a little bit more about the top two collaborative approaches in transparency. In terms of collaborative approaches, we've seen the growth of quite a number of different initiatives in this area, some focusing on specific commodities such as cocoa or palm oil, for example, and also at the category level. Again, apparel and electronics for sectors where there are a number of initiatives on that basis. There are also a number of initiatives on sustainable procurement in general, for example, through the International Standards Organization, currently engaged in developing a sustainable public procurement standard. And there are also increasingly initiatives at the level of individual countries. So the Bangladesh Accord on Fire and Building Safety, for instance, was established in the wake of the Rana Plaza disaster to engage trade unions, factory owner associations, the International Labour Organization and others to really drive forward more sustainable and comprehensive improvement in building safety in Bangladesh. And finally, just to note in relation to collaborative approaches that, of course, competition law and anti-cartel requirements can be an obstacle to be overcome in this area. That's certainly a question which needs more attention. In relation to transparency, notably following the Foxconn labor issues that I talked about at the beginning of this presentation, Apple did undertake to increase the transparency of its supply chain by disclosing eventually details, at least of all its first-tier suppliers. And we do see that legislation is increasingly being put in place in a number of jurisdictions, which would also push in that direction. California has introduced over the last few years legislation requiring companies to disclose details of what they do to prevent human slavery in their supply chain. The United Kingdom has adopted not dissimilar legislation very recently in the form of the Modern Slavery Act, which again requires companies either to provide an account of measures they have taken to eliminate human slavery from their business operations, which includes procurement and supply, or otherwise simply to make a statement that they're not disclosing that. So it is a soft reporting requirement. The European Union has passed a directive on non-financial reporting, which requires large categories of large companies to report on their non-financial impacts, which includes human rights and human rights due diligence and supply chain measures. And France is currently in the course of preparing legislation which would put on a mandatory basis the undertaking of human rights due diligence. Excuse me. Again, encompassing the supply chain management in that. There are also beginning to be a number of indices which allow consumers to investigate how companies whose products they buy rank in terms of their performance across social issues, including on transparency. So as we move to wrap this up, as a procurer, either in the public or indeed the private sector, what should be your approach? Well, in line with the concept of human rights due diligence, the first step, if your company hasn't engaged in activities in this area up till this point, would of course be to ventilate the issues and secure policy commitment and buy-in from senior management. Secondly, most likely for most companies, there would be a need to build internal capacity. Human rights is not bread and butter for most procurers or indeed anyone else working in the private sector. So there may be a need to set resources aside to allow those who will be responsible in the company to upskill or seek external assistance if necessary. After that's done, you can undertake a preliminary risk assessment, a product or service segmentation to identify which are the most integral and highest risk products and services which you buy, which carry a risk of involvement indirectly in human rights abuses or directly. After you have done that, you may be able to introduce criteria reflecting that risk assessment into screening and qualification procedures. Eventually, after that, you may be able to implement due diligence steps in the course of selection and awards. And finally, although it's the most resource-intensive, certainly part of the process, ideally you would be able to implement steps to monitor and enforce any contract terms that you have introduced in the course of your purchasing. Overall, ideally, again, you would be able to evaluate how effective the measures you have taken are in preventing or reducing the incidence of health and safety abuses or other labor abuses in the supply chain. After that, you may be able, if you're fortunate, you may be able to expand the scope of interest beyond those issues which you found most important and pressing in the beginning out to additional human rights issues, for instance, privacy and freedom of expression. And what can be the results of adopting this sort of approach? Well, here we have an example taken from the health sector. And a study was undertaken by the NGO Swedwatch, based in Sweden, and also the British Medical Association recently, which found that measures that had been implemented by selected purchasers in the UK and also by the Swedish county councils, which are responsible for all health procurement in Sweden, which had an impact, a positive impact on reducing the incidence of work-related human rights abuses in Pakistan, which is the region where most surgical instruments which are produced in the world are bought from. So in 2007, Swedwatch and the British Medical Association undertook an initial assessment of the suppliers based in Pakistan who produce surgical instruments, and they found widespread incidents of child and forced labor, health and safety breaches, abuses of trade union rights, and excessive working hours, amongst other things. From 2010 onwards, the Swedish county councils adopted a new approach to purchasing, whereby the contracts included references to the need for suppliers to respect core labour standards. The county councils also required suppliers to complete a self-assessment questionnaire, including a risk analysis. They required the suppliers to sign up to a code of conduct which they devised, and they also required the suppliers to allocate responsibility for this issue to a senior manager. In cases where the self-assessment questionnaire revealed a high level of risk for labour-related violations, the Swedish County Council purchaser arranged a follow-up meeting with the supplier to engage in dialogue, and in some cases they also arranged for an external audit to assess the extent of human rights risk in the producer in Pakistan. A 2014 study undertaken by BMA and Swedwatch found that there were significant improvements in terms of a reduced level of those kinds of abuses mentioned above in first and second tier suppliers in Pakistan, where this new approach to contracting had been implemented. On the other hand, they found that for suppliers in general in Sialkot in Pakistan, making surgical instruments, there had been no corresponding improvement. So this does strongly suggest that measures taken at the level of procurement can be effective in beginning to tackle the sorts of abuses mentioned. This means we would suggest that there is a significant business case for human rights connected to procurement. Taking the sorts of measures we've discussed can help to protect your brand and the value of your brand. They can increasingly encourage, especially millennial employees, to remain motivated and to remain with the company rather than feeling demotivated by implication in human rights abuses. Increasingly, there are efforts by lawyers to litigate on behalf of victims of human rights abuses, either perpetrated at the community level, in the context of the extractive industry, for instance, but also those who are affected by supply chain issues. And that legal risk is becoming more significant. There's the question of operational stability, which can be improved when workers are enjoying better conditions and therefore less likely to disrupt operations through industrial action or in other ways. There can be the question of simply living up to the company's own values and the consistency that comes from respecting human rights when those are something the company is committed to. The general issue of the social license to operate. Does the company have strong support from stakeholders in government and community and in the workforce? And then there's also finally questions of access to investment when, as noted earlier on, especially institutional investors as well as socially responsible investment funds are increasingly tracking and paying attention to the social performance of companies that seek lending or indeed generally in relation to their position in the market. So that concludes what I wanted to say in this introductory session on procurement and human rights, and I would be delighted to take any questions.